I have a thing I do before I go to sleep at night. I've done it every night for the last 6 years, ever since I got my life back to a place where sleep was actually possible. I lie there in the dark and I say the same thing quietly to no one in particular. I'm still here. That's it, that's the whole ritual, 3 words. I do it because there were years, a lot of them, when I genuinely wasn't sure I would be. When the walls of a cell had become so familiar they stopped feeling like walls. When the people I'd loved most had rebuilt their lives around the empty space where I used to stand. When getting through a single day felt less like living and more like an argument with gravity. I'm still here because I refused, in the end, to stop being here. And I do it as a reminder that the refusing was the whole thing. The refusing was everything. My name is Caleb Rutherford. I'm 47 years old. I live in Knoxville, Tennessee, and I run a nonprofit that provides technical skills training to formerly incarcerated people, which is either poetic or ironic depending on your perspective, and I've decided to call it both. What I'm about to tell you is the whole story, not the shortened version, not the version with the rough edges filed down to protect anyone's feelings. The whole thing. Because I spent too many years watching the people responsible for what happened to me walk through the world with their reputations intact, and I am finished with the idea that my silence is something they deserve. Let's go back to the beginning. The year was 2008, and I was 33 years old, and my life looked, from the outside, like a man who had figured some things out. I grew up in Morristown, Tennessee, a small city about 50 miles northeast of Knoxville that most people have never heard of, and the people who grew up there have complicated feelings about. My mother, Beverly, raised me and my younger sister Janelle mostly on her own after my father left when I was 9. She worked as a bookkeeper for a small manufacturing company, which meant she was meticulous about money in a way that became meticulous about everything, including my homework and my habits and the kind of people I spent my time with. I didn't always appreciate this. I appreciate it now enormously. I was good at school. Not effortlessly good, I had to work for it, had to sit at the kitchen table while Janelle watched television and put in the hours, but genuinely good. Math especially. There was something about the way numbers behaved, the way they couldn't lie to you if you asked the right questions, that I found almost comforting. I got a scholarship to the University of Tennessee, graduated with a degree in accounting, passed my CPA exam on the first attempt, which my mother framed on her living room wall in a way that embarrassed me for years. I worked at a regional accounting firm in Knoxville for 4 years, learned the business, and then took a job as controller at a mid-sized HVAC supply company called Caldwell Climate Solutions. By the time I was 32, I had worked my way up to CFO, Chief Financial Officer. Though at a company of 140 employees, the title carried less weight than it sounded. What it meant practically was that I managed the financial operations, handled banking relationships, signed off on contracts, and had become genuinely essential to the company's functioning. The owner, a man named Gary Caldwell who had built the company from nothing over 30 years, trusted me completely. He told me once over lunch that I was the kind of person a business owner spends their whole career hopping to find. I had a house in North Knoxville that I'd bought 3 years earlier, a modest 3-bedroom that needed constant small repairs that I handled myself on weekends, because I liked having something physical to solve. I had a serious girlfriend named Priya, who was a pharmacist, steady and brilliant and considerably better at relationships than I was, which is saying something because I thought I was reasonably good at them. We had been talking about moving in together. She had a cat named Wallace who had decided, over 18 months of visits, to tolerate me, which Priya said was essentially a marriage proposal from Wallace's perspective. I also had a close friendship with a man named Tommy Grier. Tommy and I had met at the accounting firm years earlier. He'd been an auditor there before going into private consulting, and he was the kind of friend you make in your 20s who somehow becomes load-bearing, the person who knows the whole chronology of your decisions and can remind you of who you were when the current version of yourself gets confused. We played tennis on Saturday mornings badly and had long arguments about things that didn't matter and short, honest conversations about things that did. In the spring of 2008, Tommy came to me with a business proposal. He had a client, a real estate developer named Vance Lowry, who was acquiring a portfolio of distressed commercial properties in the Knoxville area and needed, according to Tommy, a numbers person with a clear head to come on as a part-time financial consultant during the acquisition process. The work would take about 8 months, the money was good, and Tommy had vouched for me personally. I had done some outside consulting before, disclosed to Gary Caldwell, who had no objection as long as it didn't interfere with my work at Caldwell Climate. I met Vance Lowry once at a coffee shop. He was 50-something, well-dressed in an easy way that suggested money that predated effort, and charming in a way that I registered and then chose not to examine too closely. He explained the project, the properties, the financing structure. Everything he described was legitimate on its face. I signed a consulting agreement. I reviewed financial documents, produced reports, made recommendations about property valuations and acquisition sequencing. I deposited 4 checks over 5 months totaling about $38,000, which I reported on my taxes. In February of 2009, Vance Lowry was arrested for bank fraud. What Lowry had been doing, it turned out, was running a scheme that involved inflating the appraised values of the properties he was acquiring in order to secure larger loans from a regional bank, then diverting portions of those loans into accounts that were not connected to the properties. It was not a complicated fraud, as these things go, but it was large. Prosecutors would eventually claim losses to the bank of over $2 million, and it had been going on for several years before the bank's internal audit department caught it. I did not know about any of this. I want to be unambiguous. I did not know. The financial documents Lowry provided me were the public-facing ones, the legitimate projections and acquisition plans that any consultant would review. The fraudulent valuations, the shell accounts, the diverted funds, none of that touched the work I was doing. I was, in the terminology that would later become important, a clean layer on top of a dirty operation. But I had produced financial reports with my name on them. I had been paid from accounts connected to the enterprise, and a federal prosecutor named Diane Marsh, building the broadest possible case against Vance Lowry, decided that I was a co-conspirator. I found this out from Tommy, who called me on a Thursday evening, his voice tight in a way I had never heard from him. The FBI had interviewed him that day. They were talking to everyone who had worked with Lowry. They had my consulting agreement. They had my reports. They had the checks. I called a lawyer that night. Her name was Andrea Faust, and she was a criminal defense attorney who came recommended by a colleague at Caldwell Climate. Andrea was thorough and direct and told me on our second meeting that the government's theory of my involvement was aggressive but not crazy, which was her way of saying that while I was innocent, I was not safely innocent. The evidence that I'd worked for Lowry, received payment, and produced documents that had been used in the fraudulent loan applications, even without my knowledge, gave prosecutors something to point at. They offered me a deal. The deal was that if I pleaded guilty to 1 count of conspiracy to commit bank fraud, I would receive a sentence recommendation of 2 years in a minimum security facility. In exchange, I would provide testimony about Lowry's operations. The problem, besides the problem of admitting to something I hadn't done, was that I didn't have testimony to give. I hadn't known about the fraud. I had nothing to tell them about the scheme because the scheme had been hidden from me. When Andrea pressed the prosecutors on what exactly they expected me to say under oath, the conversation became uncomfortable. Because the answer was essentially, confirm facts about the legitimate operations and let the jury connect the dots about your knowing involvement. They want you to be a piece of the story, Andrea told me, whether or not you actually are a piece of the story. I told her I wasn't taking the deal. I had not committed a crime, I would not say that I had, and I was not going to sit in a courtroom and imply knowledge I didn't have. Andrea nodded and said, "Okay, then we go to trial." She said it calmly, but I noticed she set down her pen when she said it. The way people set things down when they want their hands free for what comes next. The federal judge assigned to United States v. Lowry et al. Was the Honorable Wallace P. Drayden, who had sat on the federal bench in the Eastern District of Tennessee for 16 years, and was, by all accounts available to me and Andrea at the time, a conservative jurist with a strong record on financial crimes cases. Strong record on financial crimes cases meant, in practice, that he convicted a lot of people charged with financial crimes. His sentencing guidelines adherence rate was unusually high, which sounds neutral until you understand that federal sentencing guidelines, particularly for financial crimes in the years following the 2008 financial crisis, were not light. He had been publicly quoted in a legal journal saying that white-collar crime was routinely under-prosecuted and under-sentenced, and that courts had an obligation to send a clear message. None of this made him a bad judge on its face. A judge can believe in strict sentencing and still be fair. The question is whether the belief in the outcome corrupts the process for getting there. In my case, the answer to that question was yes. The trial was scheduled to begin in September of 2009. Vance Lowry had taken a deal, as had two other individuals connected to the scheme. I was the only defendant going to trial. 2 weeks before trial, Andrea filed a motion to present what we believed was the central evidence of my innocence. A series of email communications between Vance Lowry and his actual co-conspirators. People who had not been charged. People Lowry had apparently protected in his plea deal. That clearly discussed the fraudulent valuation process, and equally clearly demonstrated that I was not included in or aware of those conversations. The emails had been obtained through the discovery process, buried in a production of over 40,000 documents that Andrea's paralegal had spent 3 weeks sorting through. The emails were, Andrea told me, the case. If the jury saw them, there was no rational path to my conviction. They showed, in Lowry's own words, that the consultant, me, doesn't need to know the back end, keep him clean. Judge Wallace Drayden denied the motion to present the emails. His reasoning, in a brief written ruling that Andrea read to me over the phone with a flatness in her voice that told me she was working hard to stay professional, was that the emails were potentially prejudicial to the government's case, and that their probative value was outweighed by the risk of confusing the jury on matters not directly before the court. I had to ask Andrea to explain what that meant. She explained it slowly. The judge had decided that evidence directly proving my innocence, Lowry's own words saying I was deliberately kept unaware of the fraud, was more likely to confuse a jury than to help them understand the facts. "Can he do that?" I asked. "He did it," she said. "But is it legal? Can we appeal?" "We can appeal after conviction. We can't appeal an evidentiary ruling mid-trial." "So we go in without the emails." "We go in without the emails." The trial lasted 7 days. I want to tell you about all of it, but I also want to tell you the specific moment that I knew, with a certainty that settled into my stomach like cold water, that the process had already decided its outcome before the first witness was sworn in. It was the second day. Andrea was cross-examining the government's lead financial witness, a forensic accountant named Pettis who was doing a competent job of walking the jury through Lowry's scheme and my apparent position within it. Andrea was good at this, patient, precise, building the contradiction one question at a time. She was leading Pettis toward an admission that, based on the documents he'd reviewed, there was no documentary evidence that I had ever seen the fraudulent appraisals. Only the legitimate projections. That's all I'd ever had access to. She got close. Pettis was hedging, visibly uncomfortable, and then Judge Drayden from the bench said something that I will hear in some room in my mind for the rest of my life. He said, "Counselor, I think we've covered this. Move along." Not sustained, not overruled. Move along. As if the question of whether I'd actually had access to evidence of the fraud was a topic we had collectively agreed had been sufficiently addressed, like asking a dinner party guest not to repeat a story. Move along. Andrea paused for 1 second too, the pause of a person deciding what is and isn't survivable. Then she moved along. I watched the jury. I watched one woman in the back row, a middle-aged woman in a yellow cardigan who had been following the testimony closely, turn to look at Judge Drayden and then back at Andrea, and something in her expression shifted, not dramatically, not consciously, but something. The judge had told her without saying it plainly that this line of questioning wasn't worth her attention. Juries are not supposed to take their cues from judges, but they are human beings in a room, and they watch everything. The jury deliberated for 9 hours. The verdict was guilty on 1 count of conspiracy to commit bank fraud. Judge Drayden sentenced me 6 weeks later. He sentenced me to 46 months in federal prison and a fine of $85,000, plus restitution obligations tied to Lori's scheme that would take years to untangle because I had not, in fact, benefited from the scheme, and therefore the calculation of my restitution was a legal knot that nobody bothered to loosen until much later. Before pronouncing the sentence, he made a statement from the bench. I remember it with the clarity that comes from having replayed it 10,000 times. He said that financial crimes eroded public trust in institutions. He said that the period following the 2008 financial crisis demanded that courts take a firm and unambiguous stance. He said that the sentence he was imposing was intended to send a message. Then he looked at me, directly at me, for maybe the 3rd time during the entire trial, and he said, "Mr. Rutherford, I hope that when you've completed your sentence, you'll reflect on the harm you've caused and make different choices." I was 34 years old. I had never committed a crime, and a federal judge had just told me he hoped I would reflect on choices I had not made. Gary Caldwell called me the night before I surrendered to the facility. I had already been terminated from Caldwell Climate Solutions, of course. A convicted felon cannot serve as a CFO of a company with banking relationships, and Gary had no choice, and he had been decent about it, genuinely pained, but decent doesn't undo what it undoes. He called to say he was sorry. He said he had written a letter to the sentencing court, which he had. Andrea had submitted it, and Judge Drayden had, as far as I could tell, not mentioned it. Gary said he hoped I knew he believed me. "I believe you," he said. "I want you to know that." It was the kindest sentence anyone said to me that year. I thanked him and got off the phone and sat in my house, which I would have to sell because I could not pay the mortgage from prison, and tried to understand what had happened to my life. Priya had stayed through the trial. She had been at the courthouse every day, sitting behind me, and on the day the verdict came in she had held my hand in the hallway outside the courtroom with both of hers and pressed her forehead against mine and said nothing, just stayed there. She had stayed for 3 months after the conviction, through the sentencing, through the surrender date getting set. And then one Sunday she came over and we talked for a long time, and she said things that were true and generous, and that I have never repeated to anyone. And by the end of it, we both knew what we were deciding, and I told her to go live her life in the same way people say things when they're trying to mean it, and also trying not to collapse at the same time. Wallace the cat went with her. I had gotten fond of Wallace. Tommy Grier, my friend, the one who had introduced me to Lowry, was consumed by guilt that manifested, in the way that guilt sometimes does, as distance. He visited me twice in the first year of my incarceration, and then the visits stopped. The letters continued for a while, obligatory and stiff in the way of someone managing their own discomfort. I understood it intellectually. I missed him in a way that had nowhere to go. My mother and my sister Janelle were, collectively, the reason I did not disappear inside the experience. They visited every month, sometimes together, sometimes separately, a 4-hour round trip that they made without complaint. My mother brought food every time, packed in careful containers, labeled, the way she'd packed my lunches for school, and the continuity of that gesture, the absolute persistence of her care, is something I think about when I am asked what resilience looks like. I was assigned to the Forest City Federal Correctional Institution in Arkansas, which was a medium security facility that housed primarily white-collar offenders, which sounds better than it is. The conditions were not brutal in the way of higher security prisons, but incarceration is incarceration. The loss of autonomy, the compression of time, the way the institution's rhythms eventually colonize your sense of what normal means. These are not soft experiences regardless of the thread count of the situation. What I did inside was learn. Not formally at first, Forest City had a GED program and a few vocational courses, none of which were what I needed, so I supplemented them by requesting books through the library system and through what my mother and Janelle sent. I read accounting texts to stay current. I read legal texts because Andrea had told me our appeal was viable, and I wanted to understand every dimension of it. I read history and philosophy and a surprising amount of literary fiction, which I had largely neglected before, and which turns out to be one of the better ways to understand how other people think, which is useful when you're surrounded by people and trying to survive. The appeal was filed in January of 2011. It argued primarily that the exclusion of the Lori emails had been a fundamental error that deprived me of the ability to present my defense. Andrea was good and thorough, and the brief was well constructed. The appeals court upheld my conviction. The panel found that the trial court's exclusion of the emails was within the judge's broad discretion over evidentiary matters and did not rise to the level of reversible error. I read that ruling 3 times. I set it down. I picked it up and read it again. Andrea called me, and we spoke for a long time about what it meant, what the next options were, how long they would take. I asked her, at the end of the conversation, whether she thought Judge Drayden had actually believed he was applying the law correctly when he excluded the emails. She was quiet for a moment. Then she said, "I think he believed he was trying a financial crimes case during the most politically charged period for financial crimes cases in a generation, and that he had decided what the right outcome was, and that he managed the process accordingly." "That's not an answer to my question," I said. "No," she said, "it's not." I was released after serving 3 years and 2 months, time reduced for good behavior and participation in facility programs, in November of 2012. My mother was in the parking lot when I walked out. She was wearing a coat I had never seen before, a red wool coat, and she had driven 4 hours from Morristown by herself to be there. And when she saw me, she covered her mouth with one hand and then didn't, and just stood there with her arms open. I walked out of Forest City Federal Correctional Institution into a cold Arkansas morning and my mother's arms. And that is the image I return to when I need to remember what unconditional means. The next 3 years were a different kind of hard. Not the hard of incarceration, that was over, and the relief of it being over was real, and I don't want to flatten that. But the hard of rebuilding a life with a federal felony conviction on your record is its own sustained challenge. My CPA license was suspended, revoked. Effectively, the licensing board's position on felony convictions was clear, and while there was an appeals process, it was long and uncertain. The career I had spent my entire adult life building, the thing I was genuinely excellent at, was not available to me. I couldn't get a bank account at first, which sounds almost absurd until you try to do anything in modern America without a bank account. I stayed with my mother while I sorted out the basics, which took weeks. I applied for jobs, not accounting jobs, any jobs, and watched the process stall every time the background check came back. I got a job eventually, cashier at a home improvement store. And I did it without complaint because complaint was a luxury I couldn't afford, and because my mother's red coat in that parking lot was still something I was paying back. But here's the thing about federal felony convictions that people don't fully understand until they're inside one. They don't end when you walk out of the facility. The sentence continues. It follows you into every job application, every housing search, every professional licensing attempt, every relationship where you eventually have to explain the years that are missing from your history. The formal punishment concludes. The informal punishment is open-ended. I'm not telling you this for sympathy. I'm telling you because it's the context for the next part, for the years of grinding, incremental, deliberate work that eventually got me somewhere. I had met a man at Forest City named Bernard Harris, who had been incarcerated for 8 years on a drug conviction, and who had, during his time inside, completed multiple certifications in information technology. Bernard was the sharpest person I met during my time at Forest City, by a significant margin. The kind of thinker who could hold 5 variables in his head simultaneously and run them against each other while seeming not to be paying attention. Bernard got out 6 months before me, and when I was released, he was working as a junior IT technician at a small company in Memphis, earning a modest salary, building towards something. He called me about a month after my release to check in. That call turned into a weekly call. Those calls turned into a friendship that mattered. Bernard understood something about starting over that most people in my pre-prison life, as careful and kind as they were, could not have understood from the inside. He understood it because he was living it from the same angle. 2 years after my release, Bernard and I started talking seriously about a problem we had both observed: the almost complete absence of structured, credible technical skills training for people coming out of incarceration. The certification programs that existed were often underfunded, poorly connected to actual employers, and treated the population they served as an afterthought. Bernard had found his own path, but only because he'd had unusual initiative and unusual intelligence and considerable luck in employer placement. Most people didn't have that combination. There should be a pipeline, Bernard said, on a Tuesday night phone call, that actually functions like a pipeline. He was right, and I had enough accounting background and organizational sense to understand what it would take to build one. The nonprofit took 2 years to properly establish. Not because the idea was wrong, the idea was right, and the need was real, and we had data to prove it, but because building a nonprofit from nothing while you are both working other jobs and managing the particular bureaucratic complications of having a federal record is an exercise in patience that will either develop your character or break it. Ours held. We called it the Bridgework Institute. The name came from a conversation Bernard and I had about what we were actually doing, not repairing something that had been damaged, but building a connection that had never existed, a structure between where people were and where they could be. Bernard thought it sounded like a dental clinic. I told him to come up with something better and he couldn't, so Bridgework it was. I will not walk you through all of it. What I'll tell you is the shape of it. We started with 12 participants in the first cohort, in a rented church basement in Knoxville, with donated laptops and a curriculum Bernard had developed over 3 months. We placed 9 of those 12 in jobs within 6 months. That outcome, 75% job placement, versus the industry average at the time of under 40% for reentry programs, got attention. Grant applications that had been unanswered started getting answered. By year 3, we had our own space. By year 4, we had 3 full-time staff. By year 5, we were running 4 cohorts a year and had partnerships with 6 regional employers who specifically recruited from our graduates. The Knoxville News-Sentinel wrote a piece about us. Then a regional business journal. Then, in 2019, a feature in a national nonprofit publication that resulted in speaking invitations, conference panels, and a significant grant from a foundation I had been courting for 2 years. I was also, quietly, still fighting my conviction. Andrea had found a new angle, not an appeal of the original conviction, which had been exhausted, but a petition for executive clemency at the federal level. Clemency is different from exoneration. It's an acknowledgement not that the conviction was wrong but that the punishment was unjust or has been sufficiently served. More importantly, in federal cases, a pardon restores civil rights and can, depending on circumstances, support a petition to licensing boards for reinstatement. The clemency petition was filed in 2017. It documented the excluded emails, which, though legally insufficient to reopen my case, were part of the factual record. It included letters from Gary Caldwell, from colleagues, from the employers and grant officers who had worked with Bridgework, and from Andrea, who wrote something on my behalf that I still cannot read without having to set it down. The petition was granted in 2020, in the chaotic final months of an administration that was, among its other activities, clearing a backlog of clemency requests. My pardon was number 400 and something on a list of several hundred. I found out by email, a form notification from the Office of the Pardon Attorney that I read on my phone while sitting in the Bridgework offices after everyone else had gone home, and I sat there for a long time in the quiet of the space we had built and let the weight of it settle. I called Bernard first. He said, "Finally," and then neither of us said anything for a while, and that was fine. I called my mother second. She cried. She asked if this meant I could get my license back. I told her I was going to apply. She said, "Good. You were always too good at that to waste it." I applied to the Tennessee State Board of Accountancy for reinstatement of my CPA license. The process took 14 months, required letters, hearings, documentation of character, and a formal board review. In March of 2022, my license was reinstated. I was 47 years old. I didn't return to corporate accounting. Bridgework was my work by then, the thing I was built for, the career that had grown from the worst years of my life in the way that some things only grow in hard conditions. But having the license back, having the thing they'd taken returned, that mattered. That was its own kind of sentence ending. I had kept track of Judge Drayden the way you keep track of someone whose actions fundamentally altered your life. Not obsessively, not bitterly, but in the background the way you might follow the weather in a city you used to live in. He had continued on the bench until 2016, when he took senior status, the judicial equivalent of semi-retirement, reduced caseload, still technically active. He had been written about in legal publications as a firm, consistent jurist. His rulings were cited. His reputation had, as far as I could tell, remained solid. I had never spoken to him again after sentencing. I had no expectation of doing so. In the fall of 2022, Bridgework received an application for our new mentor program. We had recently launched a track for experienced professionals to volunteer as mentors for our graduates, people who would meet monthly, help with professional development, make introductions, write references. The application was thorough, well-written, detailed in its description of the applicant's career and what they hoped to offer. The applicant was 68 years old, a retired federal judge. His name was Wallace P. Drayden. I want to tell you that I handled the discovery of this with complete equanimity. I want to tell you that. It would not be true. What I did was read the name twice, put my phone face down on my desk, and walked to the small kitchen in the back of the office, where I stood at the sink and ran cold water over my hands for about a minute, which is a thing I do when I need to interrupt whatever is happening in my body and get my thinking back in charge. The application had been processed by our program coordinator, a young woman named Tasha who had absolutely no idea who Wallace Drayden was or what he had done. She had flagged it as a strong application, retired federal judge, significant legal and financial experience, seemed genuinely interested in the mission. She had scheduled a preliminary call. I went back to my desk. I read the application again, carefully this time. He had applied because, the application said, he had been reading about Bridgework in a recent article and felt that his experience might be of value to people navigating reentry into professional life. He mentioned that he had spent many years on the federal bench and had observed firsthand the inadequacy of support systems for people leaving incarceration. He said he had retired with the feeling that he had not always used his position to its full potential for positive impact. He said he hoped to do something about that now. I'm going to be honest with you. I sat with this for a long time, not just that evening but several evenings. I talked to Bernard, who listened to the whole story without interrupting, which required real restraint from him, and then said, "What do you want to do?" I talked to my therapist, a woman named Dr. Allie Washington, who had been helping me process the shape of my experience for 4 years, and who did not tell me what to do but helped me understand what I was actually weighing. I talked to my sister Janelle, who had strong opinions about it that she kept mostly to herself, but whose silence on the subject, at key moments in our conversation, communicated what it needed to. What I was weighing was this: Bridgeworks' mission was real. Its graduates were real people whose trajectories had changed because of the work we did. The mentor program existed to serve them. The question of whether Wallace Drayden, whatever he had done, whatever his motivations now, could add something of value to that mission was genuinely separate from the question of what he had done to me. Those were two different questions, and I had learned over a long time to be suspicious of my own impulse to collapse separate questions into one, because the emotional charge of one was spilling over. I decided to conduct the intake meeting myself. We met in the Bridgework conference room on a Tuesday afternoon in November. He was older than I remembered from the courthouse, heavier, with a deliberate quality to his movements that sometimes comes with age and sometimes comes with the wearing down of something internal. He wore a jacket and tie, which was more formal than necessary, and I wondered if that was habit or nervousness or some combination. He sat down across from me. I watched him read the name placard on my side of the table, Caleb Rutherford, Executive Director, and I watched him process it, and I will tell you that the processing was not immediate. It took several seconds, and then it arrived visibly across his face, the recognition, the calculation, the particular stillness of a person who has realized they are in a room where the floor is different than they understood it to be. "Mr. Rutherford," he said. "Judge Drayden," I said. I used the title. I'm not sure why exactly. It felt accurate in some way I haven't fully worked out. A long moment. "I didn't know," he said. "I saw the name of the organization. I read the article. I didn't connect." "I know," I said. And I did know. Bridgework had become well enough known in certain circles, but not so well known that a retired federal judge in his late 60s would necessarily associate the name with a specific defendant he had sentenced 13 years earlier. He looked at his hands, and then back at me. He was a man who had spent decades in a room where he held all the authority, and now he was in a room where he held none, and whatever composure he'd arrived with was doing real work. "I've thought about your case," he said, "more than once." I waited. "The emails," he said, "the Lori emails." He said it like someone identifying something they'd put in a drawer and not opened. "I made a ruling on admissibility that he stopped, started again. The standard I applied was not wrong as a matter of black-letter law. I believed at the time that the emails would have diverted the jury from the direct evidence of your involvement in the scheme." "There was no direct evidence of my involvement in the scheme," I said. My voice was level. I was working to keep it level, and I was succeeding. "I know that now more clearly than I understood it then," he said. "I told myself the prosecution had built a sufficient circumstantial case. I told myself the emails were a sideshow. They showed Lori saying in his own words to keep me unaware of the fraud." "Yes," he didn't look away when he said it, I'll give him that. He looked straight at me and said yes. "Why are you here?" I asked, not hostilely, genuinely. The question was genuine. He was quiet for a moment. "Because I've been sitting with what I did for a long time," he said. "Since the appeal ruling, Since the clemency petition, when I received a copy, the Department of Justice notified me as the sentencing judge. He paused. I read everything that was submitted, the letters, the documentation of what you'd built, Andrea Faust's letter. He paused again. I've done a lot of things in my career that I'm proud of. I'm not able to put your case in that category. I looked at him for a long time. I'm not looking for absolution, he said. I don't expect that from you. I'm here because I wanted to do something that mattered, and your organization is doing something that matters, and he stopped. I understand completely if the answer is no. I wanted to ask in person. I did not give him an answer that day. I told him I needed to think about it and that I would be in touch. He thanked me, stood up, straightened his jacket, and left. I sat in the conference room after he was gone and did not run any cold water. I talked to our board chair, a woman named Renata Osai, who had been with Bridgework from year 2. I told her the full situation. She listened without expression and at the end said, "What does the mission require?" That was the right question. The mission required that we place the interests of our graduates above every other consideration. A retired federal judge, with active connections to the legal and business community, who could speak with credibility and authority about systems of justice to people who had been inside those systems. That was a specific and real asset to the program. Whether I liked the person who came with those qualifications was beside the point. I called Bernard. I told him what I was considering. He was quiet for a moment and then said, "Man, the universe is wild." I agreed with that assessment. I called my mother. I told her. She said, "Caleb, you do whatever you think is right." Then she said, "But don't you dare let him in there if you don't actually think he means it." I told her I thought he meant it. She said, "Then okay." I accepted Wallace Drayden as a mentor in the Bridgework program with conditions. He would start with one mentee, a graduate named Deshawn who was working toward a paralegal certification, and the match would be evaluated at 90 days. He would not serve on any committee or in any capacity that gave him institutional authority over program decisions, and I had one direct conversation with him about expectations, at the end of which I said clearly, "I'm doing this for Deshawn, not for you." He said, "I understand." Deshawn, as it happens, got a paralegal job at a mid-size firm in Knoxville 8 months later. Drayden had made 4 calls on his behalf, written a reference letter, and spent 6 months helping him understand how to present himself in legal professional settings. Deshawn sent me a text the day he got the job offer. He said, "That judge you paired me with is kind of intense, but he is on it." I saved that text. I want to be careful here, because I know how this part of the story sounds, and I want to make sure I'm saying what I actually believe rather than what sounds right. Wallace Drayden did not get what he deserved for what he did to me, at least not in any formal sense. He retired with his pension and his reputation. He was never disciplined. The rulings he made in my case were never officially characterized as misconduct. The system that produced the circumstances of my conviction looked at itself and said, "Error, within normal parameters, move on." That is not justice. I want to be clear that I do not think that is justice. But I have also spent a lot of time thinking about what justice actually requires, and I've come to believe it's not as simple as I wanted it to be in those early years, when anger was the most honest thing I felt. The man who came into my conference room was not the man who had sentenced me at 34. He was someone who had spent 13 years living with what he'd done, not suffering for it in any way proportional to what I'd suffered. I am not claiming equivalence, but carrying it, the way people carry things that don't go away, and who had found his way to a room where he had no power and sat down anyway. I am not his redemption story. I want to be very clear about that. My life is not organized around his arc. Bridgework exists because of what Bernard and I built, because of Tasha and Renata and the 43 graduates we placed in jobs last year, because of my mother's red coat in a parking lot in Arkansas. It doesn't exist because of Wallace Drayden's late career conscience. But I did not turn him away. And when I tried to explain why, The most accurate thing I can say is this. I turned him toward the people who could actually use him, and I watched him try to be useful, and Deshaun got a job. And that is a small, real thing in a world where small, real things are the only kind. Bridgework placed 61 people in jobs last year. Our 3-year job retention rate, the number who are still employed after 3 years, which is the real measure of whether what we do works, is 68%, compared to an industry baseline of roughly 30. We have a waiting list. I got my CPA license reinstated. I do not practice accounting, but I renewed it this year because I wanted it renewed. It felt like putting a thing back in the drawer it came from. My mother is 71 and in good health and still makes labeled food containers. My sister Janelle has 2 daughters, my nieces Zoe and Maya, who are 9 and 11 and have strong opinions about everything and tell them to me without hesitation, which I find enormously refreshing. Bernard Harris is the Chief Program Officer of Bridgework. He is, without question, the best person I have ever worked alongside. Tommy Grier reached out in 2019, 10 years after everything fell apart. He had been carrying the guilt for all of it, the introduction to Lowry, the way he'd pulled back when I needed him. He asked if we could talk. I said yes. We did. It was not easy and it was not fast, but we're in each other's lives again, carefully and honestly, the way friendships rebuild when they're worth rebuilding. Priya got married in 2015. I know this from a mutual acquaintance. I hope she's happy. I mean that genuinely. Wallace Drayden is still in the mentor program, now in his 2nd full year. He has mentored 3 people. He has never, in any conversation with me, raised what happened between us in court. He does his work quietly, and that is what I asked for. I don't know what he thinks about it all when he goes home at night. I don't know what version of events lives in his head, whether he has reconstructed it in ways that are more comfortable for him or whether he sits with the weight of it. I've stopped needing to know. What I know is that I am 47 years old. I am building something real. I have a community of people who depend on what Bridgework does and who have shown me, over and over, that the human capacity to start over is more resilient than I had any reason to believe in 2009, sitting across from a judge who had made up his mind before I had the chance to be heard. Every night I lie in the dark and say 3 words. I'm still here. It still works. The Bridgework Institute provides technical skills training and professional mentorship for formerly incarcerated individuals in the Knoxville, Tennessee region. If you'd like to support organizations doing this work, look for reentry programs and workforce development nonprofits in your community. They are almost always underfunded and always needed. To anyone currently inside who is reading this somehow, persist. The world on the other side is harder than anyone tells you and better than you're probably allowing yourself to believe right now. Both things are true.